Do you know that there's one weapon in America that's the most controversial, yet legally owned by millions of people? Is this weapon really as dangerous as the media portrays it to be? Or is it just a massive misunderstanding? And most importantly, is the Supreme Court finally going to end this debate once and for all? If you want to know what the future holds for AR-15 rifles and why this case is so incredibly important, make sure you watch this video until the end, because today we're going to talk about a Supreme Court case that could permanently change gun laws across all of America. But before we dive in, if you're new to this channel and you're enjoying this content, smash that like button, hit subscribe, and share this video with your friends so they can be part of this crucial discussion too. So let's get started. The Supreme Court is facing a massive question right now. This question is whether AR-15 rifles and high-capacity magazines are protected under the Second Amendment or not. The Second Amendment, as most of you know, is part of the Bill of Rights, and it guarantees American citizens the right to keep and bear arms. But the real debate here is what exactly counts as arms that deserve protection. Are military-style rifles like the AR-15 included in this protection? Or can states and local governments ban them without violating constitutional rights? This isn't just some abstract legal question. This affects millions of gun owners across the country. There are two major cases currently pending before the Supreme Court that deal with this exact issue. The first one is Vermont versus Cook County, and the second one is Duncan versus California. Both of these cases challenge bans on what politicians call assault weapons and high-capacity magazines. Let's break down what each case is about. Starting with Vermont versus Cook County. Cook County is located in Illinois, and they passed a law banning assault weapons. Now, when we say assault weapons, we need to understand what that actually means according to the law. The ban includes around 100 rifles that are specifically listed by name. This includes popular platforms like the AR-15 and AK-47. But it's not just about the name. The law also bans rifles based on certain features. These features include things like a pistol grip, a folding stock, and a muzzle brake. If your rifle has these features, it falls under the ban, even if it's not specifically named in the list. The second case, Duncan versus California, focuses on magazine capacity bans. California has laws that restrict how many rounds a magazine can hold. This case challenges those restrictions. Interestingly, the Supreme Court had previously granted review of this case, then vacated the lower court decision, and sent it back down for reconsideration after the Bruen decision came out in 2022. The Bruen case was a landmark Second Amendment case that changed how courts are supposed to analyze gun laws, so the Supreme Court wanted the lower courts to look at the magazine ban issue again, using the new Bruen framework. Now let's talk about the legal background and how we got here. Back in 2021, a lawsuit was filed in federal district court against Cook County challenging their assault weapon ban. Then, in 2024, the state of Illinois decided to pass a statewide assault weapon ban called the Protect Illinois Communities Act, or PIA law for short. This made the issue even bigger, because now it wasn't just one county. It was the entire state banning these rifles. When the case went through the court system, it reached the Seventh Circuit Court of Appeals. In a case called Bavis versus Naperville, the Seventh Circuit made a controversial ruling. They said that AR-15 rifles are too militaristic, and that military-style weapons can be banned by the government. Following this precedent, the district court upheld the Cook County ban. Then in 2025, the Seventh Circuit affirmed the district court's decision, essentially saying that yes, these bans are constitutional. Before we go further, let me just say that if you're finding this information valuable and you want to stay updated on important constitutional issues like this, do me a favor and hit that like button right now. It really helps the algorithm show this video to more people who care about these rights. And if you haven't subscribed yet, what are you waiting for? Subscribe and turn on notifications so you never miss an update. Also, share this with anyone who owns firearms or cares about constitutional rights, because this affects all of us. Now, let's look at what the petitioners, that's the gun rights side, are arguing. They're asking the Supreme Court to clarify a fundamental question. Are AR-15s actually arms under the Second Amendment or not? They argue that lower courts across the country are applying the Supreme Court's previous decisions in Heller and Bruen incorrectly and inconsistently. The Heller case from 2008 was the landmark decision that confirmed the Second Amendment protects an individual right to own firearms, not just for militia purposes. The Bruen case from 2022 established a new test for evaluating gun laws based on historical tradition. But here's the problem. Some courts are saying that yes, AR-15s are arms protected by the Second Amendment, but they can still be banned anyway. Other courts are taking a different approach and saying that AR-15s aren't even arms in the first place, so they don't get any Second Amendment protection at all. This creates massive confusion. Gun owners in one part of the country have completely different rights than gun owners in another part of the country, even though they all live under the same constitution. The petitioners argue that only the Supreme Court can resolve this confusion and provide clear guidance to all the lower courts. On the other side, Cook County and the state of Illinois are urging the Supreme Court to deny review of this case. They don't want the Supreme Court to take it up. Their response gives several reasons why. First, they claim there's no circuit split. A circuit split happens when different federal appeals courts reach different conclusions on the same legal question. When there's a split, the Supreme Court usually steps in to resolve the disagreement, but Cook County argues that no real split exists here, because all the courts that have looked at this issue have upheld assault weapon bans. Second, they argue the case is procedurally defective. What does that mean? They say that the normal discovery process was skipped. Discovery is when both sides exchange evidence and information before trial. They also claim that evidence wasn't properly presented to the court. Because of these procedural issues, they argue the case is not a good vehicle for the Supreme Court to use to decide this important question. And finally, they argue that the lower courts got it right on the merits, meaning the substance of the legal arguments supports upholding the ban. Now, here's the most important part, and this is where things get really interesting. The current status at the Supreme Court shows that this case has been relisted multiple times. What does relisting mean? When a case is submitted to the Supreme Court, the justices discuss it in their private conference meetings to decide whether to grant review or deny it. If they don't make a decision right away, they relist it for another conference. So far, this case hasn't been granted, but it also hasn't been denied. It just keeps getting relisted, which means the justices are still discussing it. The next possible conference where they might make a decision is expected in mid-February. Why does relisting matter? Well, there's statistical data from the Supreme Court covering the years 2016 through 2020 that gives us some insight. According to this data, between 31 and 43% of cases that were relisted at least once eventually got granted review. Even more interesting, between 66 and 75% of all cases that were ultimately granted had been relisted before the grant. So relisting is actually a positive sign. It means the justices are seriously considering taking the case. Hey, if you're still watching, that means you're really interested in how our constitutional rights are being decided. Show your support by liking this video if you haven't already. And seriously, subscribe to the channel because we break down complex legal issues like this in simple English so everyone can understand what's happening. Hit that share button too and spread this information because knowledge is power, especially when it comes to our rights. But here's the problem. If a case gets relisted 3, 4, or 5 times, the chances of it being granted actually start to decrease. What usually happens in those situations is the Supreme Court eventually denies review, and then one or more justices write a dissenting opinion explaining why they think the case should have been taken. We've actually seen this pattern before. There was a case called Snope that dealt with Maryland's rifle ban. The Supreme Court denied review of that case. Justice Clarence Thomas wrote a dissenting opinion expressing his disagreement with the denial. But what was really interesting was Justice Brett Kavanaugh's statement. He wrote that the court would need to take up a case on rifle bans within a term or two. That was a pretty clear signal that he thought this issue needed to be resolved by the Supreme Court soon. So here's the current concern that many legal observers and gun rights advocates have. The Supreme Court has been avoiding taking up cases about rifle and magazine bans for quite some time now. The question everyone is asking is whether Justice Kavanaugh's promise was real or just a statement with no follow-through. There's a real risk here. If the Supreme Court denies review of these cases, lower courts will feel free to keep ignoring the guidance from Bruin. They'll continue upholding these bans, and the Second Amendment will effectively mean different things in different parts of the country. That's not how constitutional rights are supposed to work. One possible reason for the delay is that the Supreme Court might be waiting for additional similar cases to arrive. There are multiple cases involving rifle and magazine bans working their way through the federal court system right now. The Supreme Court might want to consider all of them together so they can pick the best case with the cleanest legal issues and the strongest factual record. By waiting, they could potentially grant review of multiple cases and decide them all at once, providing comprehensive guidance on this issue. Think about it this way. The Supreme Court doesn't just want to decide one narrow case about one county's ban. They want to establish a clear rule that applies nationwide and answers the fundamental questions. Are AR-15s protected arms? Can they be banned? What about magazine capacity limits? What's the proper legal test to apply? These are huge questions that affect tens of millions of Americans. So the court wants to get it right. The stakes couldn't be higher. AR-15 style rifles are among the most popular firearms in America. Estimates suggest there are somewhere between 15 and 20 million of them in civilian hands. These aren't just owned by hardcore gun enthusiasts. Regular people own them for home defense, for sport shooting, for hunting, and simply because they want to exercise their constitutional rights. If the Supreme Court allows these bans to stand, it would essentially give government the power to ban an entire category of firearms that are in common use by law-abiding citizens. On the other hand, if the court strikes down these bans, it would reaffirm that the Second Amendment places real limits on what government can do to restrict gun ownership. Before we wrap up, I want to make sure you're getting all the content from this channel. If you found this video helpful, demonstrate that by giving it a thumbs up. If you're not subscribed, hit that subscribe button now because we cover important topics like this regularly and you don't want to miss out. And please, share this video with your friends, family, and anyone who cares about constitutional rights and freedom. The more people who understand what's happening, the better. So what's the final takeaway from all of this? These cases are absolutely critical for the future of the Second Amendment. The decisions that come out in mid-February or shortly after will tell us a lot. Either the Supreme Court will grant review and finally address this issue head-on, or they'll deny review and we'll likely see a dissenting opinion from one or more justices explaining why that was a mistake. If they grant review, we're looking at oral arguments sometime next term and a decision probably in 2026. That decision would set the precedent for the entire country. This isn't just about guns. It's about how we interpret our Constitution. It's about whether rights that are explicitly written in the Bill of Rights can be restricted out of existence by legislatures. It's about whether courts will follow Supreme Court precedent or find creative ways to work around it. And it's about whether the same Constitution means the same thing in Illinois as it does in Texas, or in California as it does in Florida. The coming weeks and months will be crucial. Legal experts, gun rights organizations, and millions of Americans are watching closely to see what the Supreme Court does. Will they take up the case and provide the clarity that's desperately needed? Or will they continue to avoid this controversial issue and leave it to the lower courts to muddle through? We'll find out soon. Thank you so much for watching this video all the way to the end. That shows you really care about staying informed on these important issues. If you learned something new today, hit that like button one more time. Make sure you're subscribed with notifications turned on so you catch every video we release. Share this with everyone you know because these issues affect all Americans, regardless of their political views. Knowledge is power, and by understanding what's happening in our courts, we can all be better informed citizens. I'll see you in the next video where we'll continue covering the most important legal and constitutional developments. Until then, stay informed and stay free.